America. The private natural American people did not create the corporation of the United States. The United States Incorporated did not create the private natural American people. America and Americans were in existence prior to the creation of the United States Corporation. The United States Corporation has located its U.S. headquarters in Washington, D.C., Virginia State. State territory gave land to the newly formed United States Corporation. Notice, here, we have a state giving something of value, land, to the United States. The United States Corporation agreed in the constitutional contract to protect the states. Instead, because of their bankruptcy, corporate U.S. bankruptcy, this particular U.S. corporation has enslaved the states and the people by deception and at the will of their foreign banksters with whom they have been doing business. Our forefathers gave their lives and property to prevent enslavement. Today, we are again enslaved. Private natural American people have been tricked, deceived, and set up to carry the U.S. Incorporated perpetual corporate debt under bankruptcy laws. Every time Americans appear in court, the corporate U.S. bankruptcy is being administered against them without their knowledge and lawful consent. That is fraud. If corporate bankruptcy administration is done by public policy of, by and for the mother corporation, U.S. Incorporated, the mother corporation's public policy, the corporate bankruptcy is carried out under the corporate public policy of the corporate federal government in corporate Washington, D.C. The states use state public policy to carry out federal public policy of Washington, D.C. Public policy and only public policy is being administered against you in the corporate courts today. The public policy that is dictated by all the courts from the smallest to the most powerful courts in the world is public policy. This is why I said, in another tape, that the Russian people would be enslaved into indebtedness. What will happen is that it will become public policy in Russia to have the people go into joint corporate debt. The Russians will be forced to promise to pay those debts. They will be forced to pay off on those corporate debts. Corporate public policy is the crux of the whole bankruptcy implementation. Corporate public policy is forever a corporate public policy, and the laws that have been passed since 1938 are all corporate public policy laws dealing only with corporate public policy. Understand that U.S. corporate public policy is not an American public policy. The public policy is of, belonging to, the United States Corporation. This U.S. corporate bankruptcy public policy is not of, belonging to America, the Republic. The Erie vs. Tompkins 1938 case was a decision based upon public policy. All decisions at any level since 1938 have been public policy decisions. All statutes, rules, regulations, and procedures that have been passed, whether civil or criminal, whether it is federal or state, have all been passed to implement the public policy of bankruptcy. Since 1933, when FDR came in office, he brought in public policy. He established that it was the public policy of the government to call in all the gold. It was the public policy of the government to declare banking holiday. It was the public policy of the government in Washington, D.C., the federal government, to give out government assistance. Public policy operates the same within the states. All federal court decisions can only be handed down if the states support federal public policy. The state legal system must be compatible with the federal legal system. The monkey wrench. This is why, when people like us go to court without being represented by a lawyer, we throw a monkey wrench into their corporate administrative proceedings. Why? Because all public policy corporate lawyers are pledged to uphold public policy, which is the corporate U.S. administration of their corporate bankruptcy. That's why you'll find stamped on many, if not all, our briefs. This case is not to be cited in any other case and is not to be reported in any courts. The reason for this notation is that when we go in to defend ourselves or file a claim, we're not supporting the corporate bankruptcy administration and procedure. The arguments we put forth predate 1938. We come in with constitutional law, etc. All these early cases support our rights not to be in bankruptcy. However, the corporate court, lawyers, and judges have promised to give no judicial recognition of any case before 1938. The International Banksters Corporate Plantation USA style before 1938. The law was not a public policy law. All these old cases were not public law deciding cases. Today, the cases are all decided under corporate public policy. The public policy exists in order to administer the bankruptcy for the benefit of the bankster creditors and to protect the bankster creditor. Corporate public policy can allow the creditor to say to the corporate legislatures, "I want a law passed requiring my debtors to wear seat belts. Why? Because I want to be able to milk my debtors for the longest period possible." It doesn't behoove the creditor if all of his debtors die at an average age of 38 years. What would happen to the bankster's lending, interest, penalties, increase, repayment, etc., on the entire funding and lending process if the average American lifespan was only 38 years? Why? The bankers would have to have 2.5 times the current consumer population to equal their current take. The banksters would need, instead of 250 million Americans, 600 million or even more. Maybe the banksters would need 2 billion Americans because the individual can't contract for debt until he/she is 18 or 21 years of age. Therefore, if the average lifespan is only a 38-year period, the creditor could collect on the debt for only 12 years. Now, if the banksters can just get people